Hey guys, I'm Katie Bazzle and I did my research on unintentional discrimination. So disparate impact and unintentional discrimination are actually synonyms for each other. So you can kind of define disparate impact as unintentional discrimination. Like with any other form of discrimination, disparate impact adversely affects a protected group. It's especially unique in its subtlety, though. The act of discrimination seems non-discriminatory on the surface. Any organization that uses testing requirements for promotion or requires a certain amount of education for their applicants are going to be the most susceptible to disparate impact charges. So I just kind of researched a background on what really constitutes unintentional discrimination, how it really happens, what it really means. So I looked up a classic racial study where psychologists staged an experiment and that involved two different pictures. In the first picture, there were two white men. One was armed, one was not. And then in the second picture, there was a white man and an African American male who the white man was actually armed against. And after the pictures were taken away from the participants of the study, psychologists asked them who was armed in each picture. The first picture, people would get it right, but the second picture, most people said it was the African American man, even though he was not holding a weapon. Another study conducted by BYU researchers also resulted in findings that white NBA referees call more fouls on black players. Black referees also call more fouls on white players. None of the referees, however, claim any prejudices against races that aren't their own, and they actually don't even realize that they are part of this unfair statistic. Another study presents the statistic that 56% of African Americans believe their race is significantly discriminated against. Only 16% of Caucasians agree with this statistic. The recent happenings in Ferguson that we're all pretty aware of have kind of made the nation hungry for a conversation about race. And psychologists are actually saying it would be semi-pointless at this point in time because right now we're at a point where whites and racial minorities speak a different language when they talk about racism. And by that, they mean that this is because many whites believe that racism is confined to intentional and violent occurrences. An example would be like the KKK or blatant racial slurs. Racial minorities, obviously, that made up the 56% that believe they're frequently discriminated against, are talking about the racism that causes people to believe it's the black man in the photo holding the knife, and the NBA referees, it's more of an unintentional. A sociologist at Duke University named Eduardo Bonilla Siva recently wrote a book called Racism Without Racists. It illustrates this issue in today's society. He claims that the main problem is not the folks in the hood, referring to the KKK, but the folks dressed in suits, referring to today's professionals, who are not intentionally or violently presenting their biases, but perpetuate their racial domination nonetheless. Bonilla Siva also points out a popular phrase often used during times of possible racial conflict, I don't see color. It's a great idea and basis for coexistence, but unfortunately it's rarely true, as we illustrated by J. Ross's knife photo study. When discussing his study, Ross stated that the overwhelming number of people who will actually experience the black man as having the knife because we're more open to the notion of the black man having the knife than the white man. And Ross points out that this is the most insidious thing about bias. People may absorb these things without knowing them, which is kind of the root of the unintentional part of disparate impact. So racial minorities are not the only protected class that is frequently discriminated against. There actually is a timeline of important events that put into perspective the changes in legislation that led to Title VII and the different groups that are now protected against both intentional and unintentional discrimination in the workplace. So in 1963, the government passed the Equal Pay Act. So with this act, employers were legally required to pay their female employees, which were a protected group, the same amount as their male employees under the conditions that they provided equal pay and equal quality of work in the same establishment. So basically it protected against sex-based wage discrimination. In 1964, Lyndon B. Johnson signed the Civil Rights Act into law. Embedded in this act is Title VII, which we know protects employees from being discriminated against on the basis of race, sex, color, religion, and national origin. In 1965, the Equal Employment Opportunity Commission, the EEOC, that actually oversees making sure that Title VII is acted out appropriately, is established, and with the purposes of enforcing Title VII. And its intention was to help prevent discrimination in the workplace. In 1967, Congress passed the Age Discrimination Act, which defined individuals over 40 years of age as a protected group. Originally, the Department of Labor was in charge of enforcing this act, but eventually the responsibility shifted to the EEOC. In 1972, the EEOC was given authority through a decision made by Congress to file lawsuits against private companies. Title VII was also applied to the entire federal government at this point, as well as state and local governments employing more than 15 people. In 1973, Congress passed the Rehabilitation Act, which protected those that are disabled from discrimination. In 1978, Congress amended Title VII to clarify that discrimination against pregnant women constitutes unlawful sex discrimination. So at this point, women, the disabled, and workers over 40 are added to the list of protected class originally stated for Title VII. Then finally, in 1991, the Civil Rights Act was amended by Congress in order to overrule many decisions by the Supreme Court that helped remaining parties to prevail in discrimination lawsuits. So how to handle a disparate impact case. The first rule of order is that the complaining party file a claim with the EEOC, who, as we know now, maintains compliance with Title VII. The complaining party must also statistically prove that a business practice was discriminatory towards them in nature in order to officially file the case. The party must make up a prima facie case in order to move the burden of proof to the defendant. And there are two specific ways to prove that that type of case exists. There's a pool of applicants as well as the rate of hiring. The pool of applicants describes the ratio of the employer's workforce to the pool of qualified applicants for the job. So if the plaintiff is able to show that the percentage of a certain protected class representing the workforce is significantly less than the percentage of that group in the pool of qualified applicants, then he or she has proven her case, as long as there is a connection between the practices and the disparity. The rate of hiring, on the other hand, is a comparison of selection rates of applicants between those that belong to a protected class and those who do not. So EEOC guidelines use the 4/5 or 80% rule, which requires that the selection rate for the specific protected class be less than 4/5 or 80% of the rate of that group with the highest rate of hiring in order to suggest discrimination. After the complaining party kind of makes their case, the burden of proof shifts to the defendant. The defendant will then have to justify their practices or policies and say that they are not discriminatory. An example of a disparate impact court case is Connecticut versus Teal, which is kind of boring but illustrates the steps to an unintentional discrimination case pretty well. So a Connecticut state agency was making a decision on which of its employees should be promoted to supervisor positions. The selection process required passing a written exam. As I pointed out before, organizations that test for promotions are often most susceptible to unintentional discrimination. So the exam was given to 48 African Americans and 259 Caucasian candidates for the desired position. 54% of the African American employees failed, meaning that they were not given a chance for the promotion. This 54% failure rate represented by the African American employees was 68% of the passing rate of the Caucasian employees, so less than 80%, which brings in our rule with rate of hiring. So these statistics, as I stated before, proved that the case existed as a prima facie case, and the burden of proof led the employer, since the last test was required for promotion. It was not job related. So the 4/5 or 80% rule came into play in order for the plaintiff to be victorious in that court case. And here are my references. Thank you, guys.